બીજા કેસ ચાલી ગયા છે કોઈ? સેમ એફઆઈઆર માં ડિસ્ચાર્જની અરજી છે. અને આરોપીને જવા દેજો, બપોર પછી તપાસ કરજો, કેમ કે ઓલું રેકોર્ડ આવતું નથી એટલા માટે એને જોવડાવીએ છીએ. આરોપીની જરૂર નથી, એમની હાજરી પૂરી લેજો. આને છે ને જોઈન્ટ સીપીને લેટર લખેલો છે ક્રાઇમ બ્રાન્ચ. હા, એને રેકોર્ડ માટે શું છે જરા જોવડાવજો. બપોર આને તારીખ પછી આપજો. અને પીપી આવે ને એમને કહેજો કે ભાઈ શું છે, ક્યારે તમારે રેકોર્ડ રજૂ કરવું. સાક્ષી નથી કોઈ? કોણ છે? આરોપી નંબર 13 તરફે બાકી રાખીશ, લેવાશે આજે. પછી આજે પૂરું છે ને ભાઈ? આ સાક્ષી પછી, આ સાક્ષી પછી બીજા કોઈ સાક્ષી નથી ને હવે તપાસવાનું? એટલે આજે ક્લોઝિંગ આવશે. તમારે એક તરફે જ છે ને? બીજામાં કોણ? તમે છો? કઈ બાકી રાખો ને હવે પછી. એફએસ થઈ ગયું છે બધાનું? એફએસ થઈ ગયું છે. અને બે આરોપીઓ, કયા આરોપી નથી હાજર? જેલમાંથી એક અને પૂછો ને કે કઈ આવી ગયો પાછો.
ગુલગવાસ ખાન આયા છે? અને સમીર અલી આવ્યા નથી.
બપોર પછી જોઈશું. આરોપીને જવા દેજો, વર્કઆઉટ કરવું પડશે ને કયા આરોપી માટે શું કરવું. આ બે કેસ સેકન્ડ હાફમાં રાખ્યા છે બપોર પછી.
सरफराज रुपए जाला सेंट्रल जेल सरफराज रुपए जाला
એ લોકોને ટાઈમે હાજર રખાવતા હોય તો 11:15 તો થયા ભાઈ. તમારે જેલમાંથી જાપતો ટાઈમે નથી આવતો, હવે જેલમાંથી જેલમાં માણસો નથી આવતા, આવું કેમ ચાલે? હા, તારીખ તો આવી જાય છે ને સવારના, આગલે દિવસે આવી જાય છે. તો બધાને ટાઈમે હાજર રખાવતા જાઓ. અમને કોઈ વકીલ ના આવે ને તેમને બોલાવી લો બપોરે. 1 મિનિટ અને પેલામાંથી આપી દો, લીગલ માંથી. દસ નંબર. સાક્ષી છે. બપોરે બીજા હાથમાં રાખજો, બપોરે જોઈશું. નંબર હા, એ બપોરે રાખીએ છીએ જોવા માટે. આરોપી તો એક્ઝમ્પશન જ છે, બપોર પછી બીજા સેશન્સમાં જોઈશું. આરોપી આજે સેકન્ડ સેશનમાં રાખ. બી આવી ગયું છે. ક્યાં છે પીપી ને?
આજે રેકોર્ડ પર જવાનું
હા, આપી.
આજે રેકોર્ડ પર
ચાલો, આ 54 તારીખ આપી દેજો, જાન્યુઆરી. 13 નંબર બીજા સાક્ષી તપાસાઈ ગયા છે, લઈ લેશું અમે. આ રહ્યો આવી ગયા. એમ કહો વકીલ ને બોલાવી લે. એ જ છે ને ભાઈ, આ ફિરોજ ખાન. અને એમ કે ફિરોજ ખાન ને બોલાવી લેજો. સરકારને તો સાંભળવા દો. એ કઈક તમારે વેલી ના અપાય, એમને જ પેલા કરવા દેવાય. થઈ ગઈ છે, થઈ ગઈ છે. તમારી લિખિત છે તો તમે મૌખિક નથી કરી. તો સમજીશ કે હા તો બપોર તપાસ કરજો, ટાઈમ રહેશે એટલે લઈશું.
246
ડેટ આપી દેજો. 18/12. પેલું બાકી રાખીને જોઈ લેજો પ્રોસીજર, જે પીઆઈ હાજર હોય આરોપી માટે જામીનદારને નોટિસ કરી દીધી છે. હા એને 245 માં એ જ છે ને એનબીડબ્લ્યુ. મોડેકથી તારીખ જોઈ લેજો. બપોર પછી તારીખ જોઈ લેજો.
388 આરોપી નંબર 1 છે અને 5 ની દલીલ છે અને 4 એક્શન સમજ બધી રહે છે. ફરિયાદી સાહેબ અને કંપની બધી રહે છે.
જોઈએ બાકી રાખજો.
558 સાદિક ખાન ચારે અરજી બાજુ
એમાં સાક્ષી
એમાં આવ્યો
જાન્યુઆરી તારીખ જાન્યુઆરીમાં.
ફરિયાદ 581 મયુરભાઈ આરોપી નંબર 2 અને 4 ની વિધિ પીછે હાજરી દોરે છે. 1 નંબર હાજર છે. 3 એવરેજ છે.
ડેટ આપી
બરાબર. સેન્ટ્રલ જેલ કરણ 581
કરણ અને ચિરાગ
અડાબા
એક મિનિટ. ક્યારથી જેલમાં છો તમે બંને? કેટલા? એક. જેલમાં કેટલા ટાઈમ થયા છો? તમને જામીન અરજી મૂકેલી છે એમને? પછી હાઈકોર્ટમાં ગયા હતા? હાઈકોર્ટમાં બી રિજેક્ટ થયેલી છે.
હું આજે લેખિત આપું છું.
તો એમાં તારીખ બાકી રાખજો.
261 અશ્વિન ભરેલી છે. પીએસ અને આયુ માટે હાજર છે.
બાકી રાખજો.
277 ભાવેશભાઈ વચગાળા પર બતાવે છે. નંબર 2 જામીનદાર હાજર છે. વોરંટ હાજર છે.
એને કહીને કયો કે હાજર કરે ને તો પૈસા ભરી દે. હાજર પેલી મુદત માંગતા હોય તો એને અરજી લઈ લેજો. બાકી બધાની તારીખ ના સાક્ષી એ હોય તો રજા. 24 સુધીમાં. ચલો એ નહીં. એક બાય 22 પછી
4/22, 1/23,
1/23 માં તમારું કઈ ગિયરિંગ છે? કોણ છે 1/23 માં? હા. તમારે આરોપી હાજર છે? તમે કયા કેસમાં? મેડિકલ કારણોસર. બીજા 1/22 માં તમે 1/22 માં 1/22 માં આ બધાને બપોર પછી રાખજો. એમાં કોઈ એપ્લિકેશન હિયરિંગ માટે છે ને? એ બપોર પછી જોઈશું સેકન્ડ હાફમાં. એવિડન્સ ને પતી જાય પછી. એના ક્યાં સ્પેશિયલ પીપી ઘણી બધી છે. નથી આજે રહેવા દો. આ જેલ ટ્રાન્સફર ની અરજી છે ને બધાની? હા એ કરશે રજૂ. પરચુરણ અરજી. યસ હિયરિંગ માટે છે. સેકન્ડમાં રાખીશ. 3 વાગે બીજા રાખ્યા છે તો પુરાવો પતિ તપાસ કરજો ને ત્યારે ખાલી, કેમ કે પુરાવો ચાલશે તો કદાચ, નહીતર પછી બપોરે. એટલે પેલું થોડુંક લાઈટ થઈ જાય, કેમ કે તમારી આઈ થિંક કે ચાલશે કદાચ થોડીક. ફર્સ્ટમાં કદાચ નહીં પહોંચી વળાય, કાં તો ભાઈ સેકન્ડ હાફમાં તમે 4 વાગે આવો બંને તો પણ વાંધો નથી. 4 થી 5 માં તમે બંને કન્વીનિયન્ટ જે બે સાથે બે એક સાથે જ કરી દેજો. એટલે એરેન્જમેન્ટ એવું કરો કે બે એક સાથે કરી દો. તમારી ત્યાં સેકન્ડ હાફમાં છે બંનેની? સેકન્ડ હાફમાં છે. ઓકે, તો એ આપણે એક કામ કરીએ કે અત્યારે બપોરે રાખીએ છીએ, તમારું ત્યાં પતી જાય તો અહીંયા 4, 4:30 કે તમે 4 થી 5 નો ટાઈમ તમને ત્યારે આપી શકીશ. ફર્સ્ટ સિટિંગમાં નહીં થાય, કારણ કે પેલું બોર્ડ આખું એડજસ્ટ. હા તમે તો પછી સ્ટાર્ટ કરી દેજો ને. હા શું છે એમાં તમારે મુદ્દામાલમાં? ઓફેન્સ શું છે?
આરોપી હમણાં સાહેબ બેલ આઉટ થયા છે.
એ શું છે તમારે પીપી?
આમાં અગાઉ
હા
તેમ છતાં સર મોબાઈલ અને લેપટોપ સામે તો સખત વાંધો છે.
શેનો વાંધો છે?
કારણ કે સાહેબ એમાંથી ડેટા મળ્યો
ડેટા મળ્યો છે તો લઈ લ્યો તમે એમાંથી.
એટલે સર
Copy કરીને
બનાવટી નોટોની જે પ્રિન્ટ આઉટો હતી એટલે જે ફોટા એ બધું એમાં
તો લઈ લ્યો તમે એમાંથી. લીધા છે ને FSL માં મોકલ્યું છે.
FSL માં તો જ્યારે
પછી હવે રાખવાનું શું કામ છે તમારે?
સર પંચને બતાવવા માટે જરૂરી છે.
પણ એ તો તમે ક્લોન કોપી કરી જશો ને, એની કોપી કરીને લીધી હશે ને ડેટા એક્સટ્રેક્ટ કરીને.
પણ જ્યારે પંચનામામાં એ વસ્તુનો ઉલ્લેખ કરેલો છે એ બતાવવું જરૂરી છે એટલા માટે સર પેલા ચૂંટણી કાર્ડ ને એના માટે વાંધો નથી પણ લેપટોપ અને મોબાઈલમાં
અમારા સાહેબ કોમ્પ્યુટર ક્લાસીસ ને બધું ચાલે છે એટલે સાહેબ લેપટોપમાં અમારા ક્લાસીસનો બી અમુક ડેટા છે એના માટે સાહેબ એ અમારા ધંધા માટે બી જરૂરિયાત છે
બનાવટી નોટમાં આખો ફરમો લેપટોપ
સાહેબ બધું પ્રોસિજર પતી ગઈ છે, ચાર્જશીટ બી થઈ ગયું છે, પ્રોસિજર પતી ગઈ છે. આપના અંદાજે શરત ફરમાવશો
પેલા નામદાર ને કન્વિન્સ તો કરો પછી શરત આવશે.
સાહેબ અમારા કોમ્પ્યુટર ક્લાસીસ ચાલે છે
હા.
એટલે સાહેબ અમારા જે લેપટોપ મોબાઈલ ની અંદર છે ને અમારા વિદ્યાર્થીના ડેટા હોય છે એટલે કોમ્પ્યુટર ની અંદર અમારા સાહેબ જે કોમ્પ્યુટર કોર્સીસ અમે કરાવતા બધા ડેટા હોય છે એટલે બધું
તમારો ડેટા હોય ને કોમ્પ્યુટર ના ફોનમાં ડેટા જોઈએ, બીજું શું હોય?
હા સાહેબ એ જરૂરી છે.
પેલા માલિકી કોની છે?
સાહેબ મારે કે અરજદારની છે.
કઈ રીતે છે બતાવો તો ખરા.
સાહેબ એમાં એકચ્યુઅલી એવું છે કે સાહેબ અમારી પાસે મોબાઈલના બિલ અને સાહેબ લેપટોપ બિલ એ અમારી પાસે છે ને એટલે સાહેબ મેં એફિડેવિટ રજૂ કર્યું છે એટલે સાહેબ અમારો મૂળ ધંધો આ જ છે.
શું ધંધો આ છે?
એટલે આ કોમ્પ્યુટર ક્લાસીસ નો છે એટલે સાહેબ અમે જે બાળકો ત્યાં અમે નોકરી પર
મોબાઈલ
હા સાહેબ બિલ નથી અમારી પાસે ખોવાઈ ગયું
તો તમને કેમ આપવો?
સાહેબ મેં એફિડેવિટ રજૂ કરેલું છે.
તમે એફિડેવિટ એટલે કે સત્ય થોડું થઈ જાય.
અને સાહેબ જ્યારે બી નામદાર કોર્ટ ફરમાવશે ત્યારે હું રજૂ બી કરી દઈશ.
તમારી માલિકી નો તમને કેમ રીતે આપવું?
સાહેબ અમે ઘણી શોધખોળ કરી પણ ના મળી એટલે સાહેબ અમારે એફિડેવિટ થી રજૂ કરવું પડે છે.
તો તમે વાપરો છો, તમે માલિક છો, તમારો જ છે, એ કેમ ખબર પડે?
સાહેબ એકચ્યુઅલી આ મોબાઈલ સાહેબ અમે ઘણા વર્ષો પહેલા લીધેલા છે, 3-4 વર્ષ પહેલા. અને સાહેબ અમારા ઘર બી શિફ્ટિંગ થયેલું છે એટલે લેપટોપ બી સાહેબ લેપટોપનું બિલ બી અમારી પાસે નથી સાહેબ.
તો પછી
સાહેબ અમે શ્યોરિટી આપીએ કે આ મુદ્દામાં
સિક્યોરિટી નહીં, પેલા કન્વિન્સ કરો. સિક્યોરિટી તમારે
સાહેબ અમારી પાસે મોબાઈલ બિલ સાહેબ નથી, ખોવાઈ ગયું છે સાહેબ.
તો શું કરીએ?
બિલ નથી
બાકીના
એટલે સાહેબ
ડોક્યુમેન્ટ આપી દઈએ, પેલા મળી આવે થી તમને ફરી પરવાનગી આપીએ.
આપના અંદર
હા, તો આપ નામદાર કોર્ટ જ કરે ને. તમે કઈ કન્વિન્સ કરવા માંગતા નથી
પણ
કોર્ટ.
સાહેબ અમારી પાસે એનું બિલ સાહેબ નથી એટલા
તમને એટલે જ તમને રોકેલા છે ને કે તમે આરોપીઓથી સરખી રજૂઆત કરી શકો કે કઈ રીતે કોર્ટને કન્વિન્સ છે. કાયદાથી એને ખબર ન હોય બિલ ખોવાઈ ગયું શું કરવું.
હા સાહેબ એ બે 7 મહિનાથી સાહેબ જયારે આ બનાવ બન્યો ત્યારથી જ એ લોકોને વાત કરી કે ભાઈ મુદ્દામાલ જમા લે ત્યારે બિલ ને બધી પ્રાયોરિટી રાખજો, પણ સાહેબ મળી જ નથી આવ્યું. અને એમને કીધું કે સાહેબ અમે જે તે
ઉભર આધાર કાર્ડ આપી દો, પાન કાર્ડ આપી દો, પ્લેટિનમ કાર્ડ આપી દો, ઇલેક્શન કાર્ડ આપી દો, ડ્રાઇવિંગ લાયસન્સ આપી દો, વિઝા કાર્ડ આપી દો, ડેબિટ કાર્ડ આપી દો, યુકો બેંક નું કાર્ડ આપી દો. હવે તમારે રહ્યા 3 ને 4 નંબર માટે બ્લુ કલર નો મોબાઈલ ફોન અને લેપટોપ. એના માટે કઈ રજૂ કરવા માંગો છો તમે?
સાહેબ એક મુદત આપી દો
તો પછી આટલા 2 પૂરતું બાકી રાખો, બાકીના તો લઈ લ્યો.
ભલે ભલે
આ વિડ્રો કરી લ્યો કે આનું અમે રજૂ કરશું નવેસરથી દાખલ થઈને.
ભલે ભલે
અને છતાંય સાંજ લગી રાખું છું, ત્યાં સુધીમાં કઈ મળી આવે એમ હોય તો.
હા તો સાહેબ
તમે ત્યાં સુધી ભાઈ તમારા આઈઓને કહી દો કે ડેટા જોતો હોય તો ડેટાને કોપી કરીને રાખી દે આખાનું. હા તો પછી તમારે હાજરી હા તો પણ ત્યાં સુધી બતાવો. હા તો એ તો લઈ આવશે ને.
પરિસ્થિતિ થોડી જાળવી લેપટોપમાં
લેપટોપ તમે ક્યાં કાલ ને કાલ ટ્રાયલ પૂરી કરશો? અને યથા પરિસ્થિતિ તો વાપરવાના જ છે, મોબાઈલ ફોન વાપરવાના જ છે. કોઈ ગુનાન કામે લઈ લ્યો પછી આખી બધી માહિતી થોડી તમારી પાસે પરમિનન્ટલી. હાલો હાન લગીમ કયો મને. કાલે ચાલો કાલે અને આવતીકાલ રાખો. 5 મિનિટની મુદ્દામાલની અરજી એમાં બી પછી હાથ અધર કરીને કયો કે સાહેબ નથી આ નથી.
પણ સાહેબ અમે સાહેબ ટ્રાય બહુ કરી છે એના માટે મેં ટ્રાય બી કરી છે. મેં તો તમે યાદ કરો કોઈ જગ્યાએ આ જગ્યાથી ત્યાંથી ડુપ્લિકેટ લઈ આવો.
ન પડે, આપણે રસ્તા બતાવવા પડે કે ભાઈ આ નથી તો શું કરવાનું. આપણે ન જ હોય તમારી પાસે તમારું ફોન નું બિલ નહીં હોય છે. મારી પાસે મારા ફોન નું નથી કારણ કે ઝાંખું થઈ ગયું છે. હવે એ કામનું નથી. બીજા રસ્તા ન હોય. અને કા બિલ વગરનો લીધો હશે સસ્તામાં.
history actually બનશે. actually બનશે.
શું છે આમાં પીપી? તમે ટાઈમે જોતા નથી ને અમને ટાઈમે જોવા નથી દેતા. નથી મિસ્ટર મંસૂરી પુકાર કરાવો.
એક્સપાયર થઈ જાય 20 દિવસમાં જામીનમાં જાય.
રિપોર્ટ આવ્યો જ તમારો?
આવી ગયું.
ક્યારે એક્સપાયર થયા
20 દિવસમાં જાય.
છે? એક્સપાયર ક્યારે થયા છે?
એ ડેટ નથી.
શું નથી?
મારા રિપોર્ટમાં
તમે જોવો તો ખરે ને અરજદારના તો ડોક્યુમેન્ટ જોવો. અરજદારના તો જોવા પડે ને તો જ જવાબ આપી શકશો ને.
મેં મારો પોલીસ રિપોર્ટ લખાયો.
27/11 મરણ ગયા છે. ચાલો હાજર નથી ને બાકી. ચાલો પુરાવા
20/17 પંચ હાજર છે. એસઆર યાદવ અને કુમાર શાહ એ છે.
નામદાર કોર્ટ સાહેબ જે સર
કઈ વિધિ કરવાની છે ને ક્યારે કરવાની છે? વિધિ કઈ કરવાની છે ને કઈ તારીખે દિવસ આવે છે?
સર 26 તારીખથી 31 દિવસ.
એ શું પતી ગયો છે? 4 તો આજે થઈ.
અમુક દિવાળી
અમુક કઈ
વિસર્જન પણ કરી દે. ફૂલ વિસર્જન પણ એ પણ કરો.
કઈ તારીખે કરવું છે? દેશનું પતી ગયું છે 27 ડેટ કે 28 તારીખે, કોઈ આજે 4 તારીખ થઈ.
12 દિવસ
મને ખબર ન હોય ને તમારે કઈ તારીખે બેસવું છે, શું આધાર છે બેસવાનો કઈ છે આધાર? બીજું કઈ કેવું છે? પેલા જતા રહ્યા પાછા તત્કાલ. એમાં સ્પેશિયલ પીપી નથી આવતા ને?
ત્યારે સ્પેશિયલ પીતી હતા, અત્યારે રેગ્યુલર કોર્ટ નથી. અહીંયા પીપી
ત્યાં ને પેલા મોકલો છે ને ક્રાઇમ બ્રાન્ચ લેટર મોકલો છે, એના તરફે કોઈ હાજર નથી.
એક જ આક્ષેપ માટે છે, વધારે કેસમાં મને બનાવી છે. મેં 4 માં ડિસ્ચાર્જ કર્યા છે ને 9 માં મારી જજમેન્ટ મૂકેલી છે.
એક જ બાકી છે?
ના, હજી 3 બાકી છે. વધારે કેસમાં એક જ આક્ષેપ અને બધામાં ઝેરોક્સ મૂકી છે.
તમે કોની કરી? બધા આરોપીની કરી?
ના, બધાની નહીં, 2 જણની.
કોની?
જેમની સામે ગુના સાથે કોઈ લેવા દેવા નહીં સાહેબ. હમણાં ખાલી પાસપોર્ટ બનાવવા માટેનું ફોર્મ ભરેલું છે, ફોર્મ બી સબમિટ નથી કર્યું, એમની પાસેથી જ રિકવર થયું છે. એના માટે બોમ્બેમાં અલગથી ફરિયાદ કરેલી છે, એ ફરિયાદમાં અમે નિર્દોષ છૂટી ગયા છે. એની કોપી પણ મૂકી છે સાહેબ. બધામાં ઝેરોક્સ મૂકી છે અને પાસપોર્ટ એક્ટમાં સેક્શન 15 મુજબનું સેન્કશન પણ નથી. ડબલ જીરો પાર્ટી નહીં, 15 ટાઈમ્સ.
15 ટાઈમ્સ?
15 ટાઈમ થાય સાહેબ. એક જ આક્ષેપ માટે 15 ટ્રાયલ ફેસ કરવાનું છે.
બધા આરોપીઓ જુદા જુદા હશે ને?
એ બધા જુદા. મારે તો આ 2 પૂરતું જ છે. આમને મેઇન કેસ સાથે કોઈ લેવા દેવા નથી સાહેબ.
15 નું કયો છો ને તમે? 15 કેસ?
હા, 15 કેસ.
પણ એટલે 15 જુદા જુદા આરોપીઓના બનાવ્યા છે?
ના, સેમ જ આરોપી, બધું જ સેમ આરોપી. મારે સાહેબ એજ્યુકેશન એવા કે અબ્દુલ વહાબનો પાસપોર્ટ બનાવવા માટે મેં ફોર્મ ભરીને બોમ્બે એજન્ટને મોકલેલું. બોમ્બે એજન્ટ પાસેથી સાહેબ એની પાસેથી રિકવર થયું, એને સબમિટ નથી કર્યું, એની પાસેથી જ કબજે કરેલું છે. એ ગુના માટે સાહેબ 15 કેસમાં મને નાખી દીધું. એમાં બોમ્બેમાં તો અલગ ફરિયાદ કરી છે, તો ફરિયાદમાં હું નિર્દોષ છૂટી ગયો. બાકી અહીંયા 4 માં ડિસ્ચાર્જ કર્યા છે અને બીજાના સ્ટેટમેન્ટ લીધા છે.
તારીખ જોઈ લેજો, મુદત પડશે, પણ હું ત્યાં સુધી પેલા ને આવે ને તો કઈક એનું આગળ ચલાવ. પેલા આવવાના છે? આવે છે. અચ્છા, તમે એમની સાથે છો?
Regular bail application. The filing of charge sheet first time.
What's your name?
A.S. Timbalia.
Okay, you are Mr. Timbali.
Please.
Your name? Rosa.
Yes, please. The first time after charge sheet. Before charge sheet also it was not prepared. So it is the first application. Namely, as per the FIR. The FIR was registered under section 468, 471, 194, 211, 218, and 120B of IPC.
તમારી કેમ થાય? અવાજ એમાં થાય છે. એવી રીતે થાય છે. અને બંધ થઈ.
Yes, please. These are the sections which have been invoked in FIR. The brief fact of this entire case, the FIR is registered and cause of action arise. The roots of the matter, my lord, is in 2002 and very unfortunate incident occurred. And my lord, the rain was burned. And then after, my lord, it has some unfortunate events. The post event of that event. And one event was occurred in Gulbarg society where 40 people have been died. First point of view, my lord, first point of time, one FIR came to be registered by 67 of 2002, the same day, 28th February 2002. Under 302, this incident was reported. After 4 years, in 2006, wife of one of the deceased was supposed to be a ex-MP, has approached the DGP with the written complaint that these are the accused who hatched the conspiracy and they are responsible for this. FIR was registered, but she has additionally moved one complaint. DGP has then, after order of investigation, but before that, she has approached the Honorable High Court with the help of accused number 1. The accused number 1 is Tishta. I'm sorry, here in FIR I have been shown as accused number 1.
3. Yes.
I'm talking about Tishta Shetalwar, Miss Tishta Shetalwar. So, my lord, it was filed before the Honorable High Court. The Honorable High Court has dismissed the petition with the observation that you have bypassed the remedy which is available for the registration of FIR, that you can approach the concerned court. That is why it was dismissed.
Yes.
Meanwhile, my lord, NHRC, National Human Rights Commission, has approached the Honorable Supreme Court by the writ petition number 109 of 2003. This is posted before it, where, my lord, the Honorable Supreme Court had stayed the proceedings of Gulbarg case and issue the direction to the Gujarat government to form the SIT, Special Investigation Team. Where, my lord, SIT has filed thrice after conclusion of the investigation, 3 charge sheets were filed. Now, my lord, against the order which is passed by the Honorable Gujarat High Court, the victim, the wife of deceased, named Jakia Zafri, she has filed the SLP before the Honorable Supreme Court by the SLP number 1088 of 2008, where the Honorable Supreme Court, that is also, my lord, along with the accused number 1, Miss Shetalwar, where the Honorable Supreme Court has directed Jakia Jafri to be examined by SIT, Special Investigation Team, and look into the matter and prepare a report and direct it to submit before the Supreme Court. Matter was posted after 3 months. In this case, my lord, the Honorable Supreme Court has also appointed amicus curiae to scrutinize the report. Then after, my lord, on 12th September 2011, Supreme Court directed Special Investigation Team to submit the report before the concerned court. On 8th February 2012, surprisingly, a closure report was filed by the SIT, which was running in more than 26,000 pages. This report only contains 26,000 pages. And there are many reasons which are given that the prima facie cognizable offense is not made out. And the complaint which is filed by the Zakia Zapri, that does not have any substance. So far as my lord, those additional accused are concerned. Against that closure
report was pertaining to the Gulbarg case.
Gulbarg case. It is pertaining to the Gulbarg case where my lord
40
Zakia
persons.
Zapri has raised the grievance that these are the, she has narrated a list of accused. That these are the accused, my lord, that they are hatched the conspiracy and they are behind this entire incident. But in that final report was filed. Against the final report, my lord, the complainant along with the accused number,
So far as the 40 persons missiles is concerned,
that is there.
that was a case that was
That is
already-
a separate, yes, it is
separate.
there.
Thereafter, the victim or Zakia Jafri filed an application before the High Court,
Initially before the DGP,
then to High Court and then
Please.
Supreme Court,
yes,
alleging that some more persons were involved.
please, ma'am. So, my lord,
And,
that closure report,
in pursuant to that application oblique complaint made by the
Zakia
victim,
Zapri.
seat was appointed and seat
Yes.
filed a closure report.
Yes. Seat was appointed even in NHRC also, my lord, the Honorable Supreme Court has taken it very seriously. These are the mass killing. There must be some special investigation teams to be constructed so that at least truth can be come out. Then, my lord, that closure report was protested by the original complainant. Ultimately, it was accepted by on 26/12/2013. The learned magistrate accepted that closure report. Against that,
Yes.
the original complainant has preferred criminal revision application before the Honorable High Court. The same was rejected on 5th October 2017.
Yes.
Now, my lord, against that order, she has preferred SLP. Complainant in support of one of the accused before my lord, not me, but the co-accused, the lady accused. And SLP was dismissed on 24th June 2022. With the detailed judgment,
24.
24th June 2022. With the detailed separate judgment, my lord. Where
Yes.
all things were considered, the SIT report, the report of learned amicus curiae, everything was considered in that judgment. Now, within 11 hours, the present complainant has registered the FIR. With the awareness that I have gone through all the records, I have gone through the material available on public domain, and then I come to the conclusion that the cognizable offense is made out, and that is why he became a complainant, first informant in this FIR, and within 11 hours, he has registered the FIR. Where the surprisingly, I am very much surprised from the computerized memory as well as the ability to scrutinize the record of 20 years, where only final report itself, as per the case of complainant, running in a 26,000 pages. But he says with the awareness, specific awareness, that I have gone through the material as well as the material available on public domain, verify everything, and I found that that cognizable offense is made out. And then after he has given certain illustration that by this offense is made out, and then my lord, FIR came to be registered. So my lord, this is the background of the registration of FIR. Now, if my lord may kindly turn to the FIR. Annexure A I have annexed.
Within 11 hours of the decision of the Supreme Court.
The Supreme Court has declared on 24th.
Hmm.
So I believe that, my lord, generally, even in my case also, when the Supreme Court declared something, the judgment, such a bulky judgment, so it uploaded around 4 or 5 o'clock. I let it be assumed it was uploaded 3 o'clock. Then after 12 o'clock in midnight, before 1 second. So, sir, FIR note, the duration is relevant. Sir, the incident duration is 1-1-2002 થી લઈને 25/6/2022. 25/6/2022 is the date of, it is a 1 day after the date of judgment. FIR was registered 0000, 12 o'clock in midnight till 11 o'clock. During this time, the offense was declared. Information was received on 25/6/2022, 11 o'clock. This is also, my lord, contradictory for their own version. They are saying that it was started from 12 o'clock in midnight, completed 11 o'clock on 25/6/2022, and information was received on 25/6/2022. These are the technical issues. It will be helpful to me in trial, I understand. But this is the, I am very much impressed with the ability of complainant. That is why I am drawing the attention of the Supreme Court. Now, if my lord may kindly see the FIR, starts from 3 accused have been joined. First accused is my client, Sanjeev Rajendra Bhatt. Second is RB Srikumar. Third is Dishta Setalwal. The element of FIR, it starts, my lord, that I am serving as a police inspector in crime branch, Ahmedabad city, since March 2019. I am submitting this complaint, first information on behalf of state, against Dishta Setalwal, residing at so-and-so, so-and-so. Sanjeev Rajendra Bhatt, presently lodged in a Palanpur district jail, permanent residing so-and-so, so-and-so. Honorable Supreme Court of India, in its judgment pronounced on 24/6/2022, diary number so-and-so, Zakia Ehsan Jafri versus State of Gujarat, inter alia observed in paragraph number 88. So here, my lord, the paragraph number 88 has been shown as a cause of action to register the FIR. I may skip entire paragraph, read only last line. As a matter of fact, all those involved in such abuse of process need to be in the dock and proceed in accordance with law. So here the first informant is saying that the cause of action to register the FIR arises to him because Supreme Court has observed in paragraph number 88 that dealt with the accordance with law. So he felt that he can deal with the accordance with law by registration of FIR. This is his belief, personal choice. But it was filed by the state. That is what he has stated. Here, my first submission to this Honorable Court is that in nowhere entire judgment I have gone through, nowhere it was said by the Honorable Apex Court that cognizable offense is made out, issuing direction to register the FIR against the concerned. It is not mentioned in entire judgment. It is the belief of first informant that when it is stated to deal with accordance with law, here, my lord, accordance with law, this direction, the intention behind the Supreme Court, because various authority involved, my lord, in this entire episode. The first, that is the concerned court, Metropolitan Court number 11. Second, Special Investigation Team. Third, Nanavati and Mehta Commission. Fourth, Honorable High Court. Fifth, Honorable Supreme Court. None of this authority has never taken any cognizance against any of the accused that you have produced certain. I will come on that aspect, that what are the allegations against the accused. But this is, he personally believed that this paragraph hit me and that is why I am registering here. So, my lord, in my humble submission, his belief is absolutely false. Now for that ahead, my lord, I may read. The said matter pertains to the complaint submitted by, in the name of Srimati Zakia Naseem Ehsan Jafri, dated 8/6/2006, to the Director General of Police, Gujarat State Police Bhavan, Gandhinagar, for the registration of FIR under Section 302, read with 120B, and Section 195, and read with 114, 186, 153A, 186, 187, under Section 6 of Commission of Inquiry Act, the Gujarat Police Act, the Protection of Human Rights Act, the said complaint contained allegations pertaining to the incidents which took place in Gujarat as affirmed of Godhra train burning incident. The brief background of the matter is as follows. So here the contention is that Zakia Zafri has filed one complaint, and that is why, my lord, the background is. First, incident in Gulbarg society. Pursuant to the killing of car sevaks traveling in Sabarmati Express train at Godhra railway station on 27 May 2002, a call for the Gujarat Bandh was given by the Vishwa Hindu Parishad and other Hindu organization on 28 May 2002. On the day of Bandh, 28 May 2002, a huge mob indulged in an properties, shops, houses of Muslims, as well as Madrasa Mosque of the Gulbarg Society located in Meghani Nagar, Ahmedabad city, resulting in death of 39 Muslims, including late Ehsan Jafri, ex-member of parliament. Late Ehsan Jafri, ex-member of parliament, fired from his private licensed weapon in self-defense, causing injuries to 15 persons in the mob. Second, offense registered at Meghani Nagar police station. An offense was registered, white CR number first 67 of 2002, Meghani Nagar police station, commonly known as Gulbarg Society case 28 May 2002, on completion of investigation by the crime branch, Ahmedabad, 6, including 5 supplementary charge sheets, were filed in the Court of Metropolitan Magistrate, Court number 11, Ahmedabad, during the period of 3/6/2002 to 18/10/2004. Third, NHRC petition and formation of SIT. Meanwhile, the National Human Rights Commission had approached the Honorable Supreme Court by the way of writ petition number 109 of 2003. Pursuant to the same, the trial of Sessions case number 152 of 2002 and others.
You can,
Emanating the offense.
you can skip this because that is all what already you have conveyed.
Yes, my lord, but it is, the reason is this wise I am reading, because it is then only, my lord will get the idea how the entire episode was occurred. Because it's a very 20 years events are there. That is why I'm just trying to draw the attention so that only then after I will read only the allegation against me.
Against you.
Yes. Gulbarg Society and other Godhra rioting cases were stayed by the Honorable Supreme Court. Constitute a 5-member special investigation team to undertake inquiry investigation, including further investigation in the 9 cases stated there. The SIT filed 3 supplementary charge sheets before the concerned Metropolitan Magistrate in this case. Complaint of Srimati Zakia Zafri. This is relevant, my lord. Srimati Zakia Nasim Ehsan Jafri submitted a complaint dated 8/6/2006 after more than 4 years of the incident to Director General of Police, Gujarat State Police, Bhavan Gandhinagar, for the registration of FIR under section 302, read with so and so. On receipt of the complaint, the DGP Gujarat entrusted the matter to the additional DG Intelligence Gujarat to inquire into the same, who took up the complainant and fixed dates to record the statement of Srimati Zakia Jafri. Zakia Jafri has stated that till an offense on the basis of her complaint was registered, she was not ready to make any statement, and instead of that, the complaint given by her may be treated as a FIR. Petition in the Honorable High Court by Srimati Zakia on 1st March 2017, Zakia Jafri, supported by Tishta Shetalwad, Ms. Tishta Shetalwad, Secretary Citizen for Justice and Peace, filed an application in the Honorable Gujarat High Court. I am pausing here for a moment. Here, my lord, the co-accused, Ms. Tishta, she was running one NGO in the name of Citizen for Justice and Peace. The allegation is that Ms. Zakia Zafri filed a complaint supported by her, co-accused, approached the Honorable High Court with her support. It was prayer by the petitioner in the said application direct the DGP to Gujarat to register FIR and further direct to the same to be investigated by the independent agency, CBI. The Honorable Gujarat High Court passed an elaborate order dated 2/11/2007 dismissing the said petition. It was clearly mentioned in the order that the petitioner did not adopt the procedure to file the complaint under section 190-200 and directed the petitioner to file the appropriate private complaint if she wishes to. 6. Petition before the Supreme Court. Srimati Jakia Jafri, aggrieved by the said order, Jakia Hassan Jafri, and Citizen for Justice and Peace, again before the Supreme Court. Throughout, Secretary Ms. Seshta Shetalwal filed a special leave petition, criminal number so and so, in the Honorable Supreme Court of India. The Honorable Supreme Court, in the said special leave petition, passed an order dated 27/4/2009, which read as under follow. Having heard learned counsel for the party, we direct the complaint dated so and so, which the petitioner here in the claim to have sent to the DGP of Gujarat shall be examined by the SIT. Constituted pursuant to the order of this court, the SIT shall look into the matter and take steps as required in the law. Give its report to this court within 3 months. Call this matter after 3 months. This case shall be heard along with the writ petition 109/2003 connected matters. Inquiry and investigation by the SIT and scrutiny by the learned amicus curiae. In this matter, the inquiry and further investigation was conducted by the SIT and periodically report were submitted before the Honorable Supreme Court. Honorable Supreme Court had directed the learned amicus curiae to scrutinize all the reports and give opinion on the same. Order of Honorable Supreme Court. The Honorable Supreme Court of India, after carefully consideration of all reports submitted by the SIT, the opinion given by the learned amicus curiae passed a final order on bar 9/2011, wherein it was directed as under. Accordingly, we direct the chairman of SIT to forward a final report along with the entire material collected by the SIT to the court, which had taken a cognizance, that is a court number 11, criminal report 67/2002, as required under section 173(2) of the code. Closure report. The Supreme Court has directed to send all the investigation report along with the evidence to the court. Now, my lord, what the SIT has done. The closure report before learned man, as per the order of the Honorable Supreme Court, final report under section 173(2) code was submitted on 8/2012 in 2 volumes by the investigation officer for the perusal of consideration and appreciation of learned Metropolitan Magistrate Court number 11. In the said closure report, it was concluded by the SIT that no prosecutable material is available against any of the accused persons. All the documents collected and Salomon's record during the course of inquiry investigation along with the reports of learned amicus curiae were submitted before the learned court. Copy of the closure report and record submitted running into 26,000 pages before the learned court was supplied to the complainant. Protest petition, the complainant preferred protest petition before the learned magistrate. Order of magistrate, the learned metropolitan court, after extensively hearing of the parties, accepted the closure report, denying to the lodge to the complaint, and thus thereby the protest petition of the petitioner was not entertained. Wide order dated so and so. Revision application in High Court. The complainant filed a criminal revision application 205/2014. Honorable High Court Gujarat, and wide order dated 5th October 2017. Prayer of the petition were rejected. Special leave petition in the Honorable Supreme Court. Srimati Jakia Jafri and Srimati Seshta Shetalwal have filed special leave petition before the Honorable Supreme Court on bar 9/2018, having diary number so and so, against the impugned final judgment and order dated 5/10/2017, in which wide order dated 24/2022, the prayer of the petitioner was rejected, which contains elaborate reasons. This is the last litigation, my lord. In the context of the aforesaid fact and other fact, it appears that several cognizable offences are committed by the accused persons individually, collectively, and or in collusion with other individual entities, organizations. In view of the same, as Police Inspector Crime Branch, I had pursued the records of the various proceedings and other material either in official record or in a public domain, and have prima facie found that the following criminal cognizable offences are committed by above named accused and various other accused persons. The following are only few of illustrative instances, as investigation would reveal much more considering the totality of various calculated actions taken by the accused person. Here, my lord, I am pausing, my lord, for a moment. Here, the case of investigation agency projected against in this FIR is that just to humiliate or harm the image or falsely implicated several political leaders several political individuals, several other accused. Srimati Zakia Zafri has preferred a complaint that was false. It was till Supreme Court it was reached, supported by one of the lady co-accused, and then after Milord, during this course of investigation, the material was collected by the Special Investigation Team SIT, where certain material prima facie reached to the conclusion that from those certain materials, cognizable offense is made out, and that is why we are registering this FIR. This is the crux of matter. So, first submission to this Honorable Court is that the entire episode starts with the name of Zakia Zafri and the case which is filed by her. Admittedly, one of NGO Milord is associated with her because one of the petitioner is there. My name never been reflected. Never been reflected that I supported her or I advised her or I provided tuition to be how to be a witness, how to be examined in a court. That is not the allegation even in this FIR. But FIR is for that because she has wrongly implicated certain individuals. That is why FIR is raised. Now, if my lord may kindly see the allegation starts, there are three segments, three types of allegations raised against me. First, I have sent 2 fax messages. Those 2 messages are false, fabricated, or forged one. I have done certain emails. I'm sorry, second allegation is that I was not present in the meeting as per my say. I said that this is my case, that as per my say, my view and my point of time, that I was present in a meeting which was held at the CM house. I was a part of that meeting. So that is come to be false, and that is why the second allegation. The third allegation, during the April 2011 and May 2011, for 1 month, I have sent various emails to police and to some organization, NGOs, and this all are the reasons. That is why I have been joined as an accused. So all reasons are required trial, but this is the only nutshell allegation. I'll read. First allegation: Sanjeev Bhatt, the then DIG, had sent a letter Sanjeev Bhatt, the then DIG, had sent a letter dated 3/2011 to the Secretary, Honorable Justice Nanavati and Justice Mehta Commission, to inquire and close therewith as Annexure D, which is a copy of message number D2, Communal Alert 174 of 2002, dated 28/2002, which he claimed to have sent to the different authorities under his signature. Subsequently, on 4/1/2012, Sanjeev Bhatt forwarded to the chairman, SIT, a copy of his letter, so-and-so, dated 4/1/2012, addressed to the Secretary, Justice Nanavati Commission of Inquiry, enclosed therewith a copy of fax message number D2 to Communal Alert 100 of 2002, dated 27/2002, claiming to have sent the same under his signature. The oral and documentary evidence available on record of SIT conclusively proves that this fax messages produced by Bhatt have been forged, fabricated, manipulated subsequently with an ulterior motive, and have been produced by Sanjeev Bhatt for first time before the Nanavati Commission of Inquiry and subsequently before the SIT in January 2012. This act of forgery was done by Sanjeev Bhatt with an express intent to implicate various persons under the grave sections of law. This is the first allegation. The second allegation: Sanjeev Bhatt had falsely claimed before the SIT that he attended a late night meeting on 27/2002 called by the Chief Minister at his residence, investigation conducted by SIT under the supervision of the Honorable Supreme Court conclusively established that Sanjeev Bhatt was not present in the said meeting, and he has made above stated claim 9 years after the incident to falsely implicated various persons in grave sections of law with a view to substantiate such false claim and with a clear intention of involving innocent persons with offense punishable with life. He used, forged and fabricated several documents. This is the second regarding my presence in court. Third, Government of Gujarat, vide its later dated 22/6/2011, forwarded to SIT a set of email exchange between Sanjeev Bhatt DIG under the suspension, Gujarat Police and certain individuals co-accused during April and May 2011, which are the only mails available till the date. The scrutiny of the material forwarded by the government of Gujarat established that certain vested interest individuals and organizations, including Sanjeev Bhatt, different NGOs, some political leaders and organizations, were hatching a criminal conspiracy to use various forums such as Honorable Supreme Court, SIT, for settling their scores and achieve an unlawful and object implicating innocent individual in the offense punishable with life. This fact further go on to show that Sanjeev Bhatt had been colluding with some persons with a vested interest to see that the criminal charges are made against several persons. For achieving his criminal intent, Sanjeev Bhatt received some packets from others to achieving criminal conspiracy of involving individual serious offences punishable with life. There is thus clear inducement, incentives into bracket monetary and others received by Sanjeev Bhatt from the fact available on record. Such similar and other inducement, gratification, incentives having been received by him also needs a detailed probe and investigation. This is the allegation. Now, next, my lord, this is the one part of FIR. Now, further part is that most of the allegations in the complaint of Srimati Jakia Jafri are drawn from the 9 affidavits filed by RB Sri Kumar. He is one of the accused in this FIR. Before Nanavati Shah Commission, it is a matter of record that RB Sri Kumar, retired IPS, was posted as an Additional Director General of Police Armed Unit, Gujarat. At the time of riots, the facts stated by RB Sri Kumar in the 9 affidavits filed before the Justice Nanavati Shah Commission of Inquiry does not derive any of its content from the personal knowledge, information which he might have revealed as the occupant of this post. Similarly, perusal of his statements recorded by the SIT reveals that the knowledge information of all the facts pertain to be the complainant mentioned by him is acquired after he was posted as additional DG Intelligence Gujarat. Further, RB Sri Kumar did not make any allegation against the state government in his initial 2 affidavits filed before Justice Nanavati Shah Commission of Inquiry and started at alleging only for from third affidavit on 9/4/2005. Fifth, RB Sri Kumar has stated before SIT that he took over as additional DG Intelligence on 9/4/2002 and that he had been given many verbal orders, of which many were illegally and against the spirit of Constitution of India. He had further stated that he had got issued a register from Shri Opui Mathur, the then IGP, Administrative Security, to record verbal instruction from higher officers, is that DGP and above. He has further stated that he had made entries about the verbal instruction in his register from 16/4/2002 થી 19/9/2002. Investigation conducted by the SIT conclusively proves that in the said register, Sri Kumar had done antedating and affixed secret and round office stamps without the knowledge of issuing authority. This act reflects that Sri Kumar had done this acts and many other deliberately to falsely implicate certain persons in grave sections of law. 6, there is a material in final report submitted by the SIT which indicates that the Tishta Shetalwad had conjured and concocted, forged and fabricated facts and documents or evidence, including fabrication of documents by a person who were prospective witness of the complaint. It is not only a case of fabrication of documents, but also influencing and tutoring the witness, making them depose pre-typed affidavit, as has been noted in the judgment of Honorable Gujarat High Court dated so and so in criminal message so and so. Srimati Zakia Zafri, in her cross-examination in Gulbarg Society case, this is a very relevant, her version is there. CR number so and so as a prosecution witness number 337 had conceded that she knew Tishta Shetalwad for some time and also about having met RB Srikumar after the incident. She had stated that RB Srikumar had come to the Gulbarg Society, 28 May 2002, and upon the completion of 4 years, she had met him. She had also stated that RB Srikumar was presently working with Tishta Shetalwad. She had also admitted in her cross-examination that she had given a statement on 22/8/2003 before the Nanavati Shah Commission. After giving that statement, she had no occasion to read copy of that statement. This indicates that she was tutored by Tishta Shetalwad of act that she had to admit in cross-examination. She had also admitted in her cross-examination that she had throughout followed the instructions of Tishta Shetalwad. In the final supplementary report filed by SIT in Gulbarg Society case being 67/2002, it has been clearly noted that 19 witnesses, instead to take on record their prepared signed statements, which according to them were prepared by Tishta Shetalwad and advocate so-and-so, and did not show willingness to give their own statement. The statements so presented were stereotyping copies, computerized, prepared statements and given to them by Tishta Shetalwad and advocate so-and-so, and they had merely signed such papers statements. The above referred offense illustratively stated herein above inter alia clearly establishes that Sanjeev Bhatt, RB Srikumar, Tishta Shetalwad and other had conspired to abuse the process of law by fabricating false evidence to make several persons to be convicted for an offense that is punishable with a capital punishment, thereby committing an offense punishable under section 194 Indian Penal Code. Furthermore, it has been established in the course of investigation one by SIT that Sanjeev Bhatt, RB Srikumar, Tishta Shetalwad, other had instituted a false and malicious criminal proceedings against the innocent people with the intention to cause injury, an act punishable under section 211 Indian Penal Code. Sanjeev Bhatt and RB Srikumar, who at that time of their acts of commission and omissions were public servants, they had framed incorrect records with the intent to cause injury to several persons for which they are culpable under section 218 of the Indian Penal Code. Sanjeev Bhatt, RB Srikumar, Tishta Shetalwad and other had conspired and had prepared false records and dishonestly used those records as the genuine ones with the intention of causing damage, injury to several persons, thereby having committed offense inter alia punishable under section 468-471 of IPC. This FIR may kindly be registered not only in the context of the above material and other material judgment of the Honorable Supreme Court referred above in a general and paragraph quoted in a particular and also independent grounds inter alia for findings behind the scene criminal conspiracy and financial other benefits inducement for commission of various serious offences in collusion with other individuals, entities, organizations. Lord, this is the FIR. Lord, my submission to this honorable court is that by mere reading of FIR as it is, without raising any doubt, one person, my lord, who lost her husband has filed a complaint. Whether it's true, false, now it is proved that it was false complaint. She was supported by one of the NGO, that is the government of FIR. Along with that, my lord, she has approached the court, where my role is not coming out from anywhere. The second aspect is that, my lord, till Supreme Court, I may be permitted to supply the case status of Supreme Court where, my lord, this judgment is passed. As per this case status also, my lord, there were two parties. One is Zakia Zafi and second is the co-accused. I'll supply it. This is the case status, my lord, may kindly.
Yes.
My lord, may kindly see the case status from this FIR is Supreme Court SLP 34-207-2018. After revision, જેના માટેથી FIR થઈ. Here, my lord, this
So we accept that you were not there.
yes, I have.
Okay. Yes.
Co-accused were there. Co-accused was there. I was not there. So, my lord, this is the submission to this honorable court that I was not. So there is no possibility that me and Zakia Zafri anytime point of time hatched a conspiracy. Now, if my lord may kindly see the allegation against me, first allegation that is regarding fax message that Sanjeev Bhatt sent a letter on 30/2011. Now, this is the, my lord, letter dated 30/2011. The allegation is that I have sent along with the different fax messages. My submission, respectful submission to this honorable court is that this charge sheet contains thousands of pages, but this letter is missing. Where, my lord, this is the foundation of their own case. The investigation agency relying on the letter that I have forwarded to the special investigation team by the letter dated 30/2011. My learned senior friend may correct me if I am wrong. This letter is not parcel of the charge sheet. Later, ખાલી લેટર 30/2011 જે લેટર સંજીવ ભટ્ટે નાણાવટી કમિશન ને મોકલ્યો ને એ it is not the parcel of the charge sheet. Now, just to show my bona fideness, because, my lord, what I personally feel, my client, that the conclusion, after the conclusion of the investigation, the prosecution either deliberately or by mistake, reason well known to them, but this fact remains same, that prosecution has produced many documents which are not complete. It is incomplete documents, such as they have produced my fax message, which I have sent under this letter, but they have not produced this letter. So, just to show my bona fideness, because if you read something without context, selected documents, if you read selected documents, then maybe, my lord, the true picture cannot be clear. So that is why, as a bona fide, my lord, party of the suit, though being an accused, I have filed application before this honorable court under section 207 that you are relying upon this letter in FIR as well as in charge sheet, but you have not produced. So I have requested for the copy of this letter where they are objecting, and that application is pending and before my lord for the consideration. So, my lord, my respectful submission to this honorable court is that the document which is necessary, essential, as per their own cases, document is not filed before this honorable court, reason well known to them. And I have requested for that document. Now, my lord, the fax message are concerned. If my lord may kindly see, they have in FIR also they have stated, even in charge sheet, even the fax message produced, they have marked this message as an annexure D. Again, my lord, my apprehension was right. Annexure A, B, and C. Because if you read something, my lord, out of context, then that will give a different picture. But if you read something with the complete context, that will give the clear picture. This is my respectful submission to this. So that the fax message which they are claiming they have annexed as annexure D, but fax message A, B, C, which I have sent to the Milord Commission, are these three annexure are not parcel of the charge, are not produced. That is also, Milord, I have requested under 207. Now, if my lord may kindly see, this report, which is prepared by SIT, was forwarded, where this fax message and this all allegations are raised against me in that report also, was forwarded before the court number 11. That final report running in at 26,000 pages, that no material is there to prosecute against this accused. That report, final report by, I think the name is Mr. A.K. Malhotra, SIT. A.K. Malhotra. A.K. Malhotra. By Mr. A.K. Malhotra, where the same allegations are there against me about this fax message. So, Lord, when the Honorable Magistrate of Court number 11 has accepted that report, at that time, neither it was requested by the SIT that no, he has produced forged document, so cognizable offense is made out to register the FIR, the 340-195. That was not the request of SIT also in the report. That is the first, in my humble submission, first instant and cause of action arise to declare a cognizable offense against me. So SIT, who has investigated, prepared a report with the same allegation, forwarded it before the magistrate, neither SIT has requested nor the learned magistrate has issued direction to register the FIR and accepted the report. In my humble submission, matter ends there. When the learned court has accepted the report, in a possession of all the allegation which is raised by SIT against me, could have issued direction to register the FIR, but the court did not find it that I made a cognizable offense, because same they have produced, same without annexure ABC and without data. So, my lord, my humble submission to this honorable court, that is the forwarded to SIT. It was now this all happened, my lord, before the proceedings of Nanavati and Mehta Commission. This fact came on a record of even Nanavati and Mehta Commission. I have produced this, I have filed this, I have sent this letter, I have produced this fax messages that I was present in about Gulberg incident. Even Nanavati and Mehta Commission never says that I committed a cognizable offense and FIR is required to be filed, or under 340 or 195. The prosecution is required to be initiated against Mr. Bhatt. So, in my humble submission, neither SIT nor learned magistrate nor Nanavati and Mehta Commission never ever said that cognizable offense is made out and FIR is required to be lodged against the petitioner. Now, if my lord may kindly see, whatever I have deposed before the commission, which allegedly they are saying that it was false and fabricated, that I have deposed before the Nanavati and Mehta Commission. As per my lord, section 6 of Commission and Inquiry Act, this cannot be used against me. Because that is I was one of the witness of Nanavati and Mehta Commission. So section 6 is there to rescue me, my lord, and no prosecution can be initiated against me. That is the one of the ground I have taken in my discharge application. Now, my lord, the allegations, I put a question to myself that how the prosecution is saying, investigation is saying that those two fax messages are forged or fabricated. When I scrutinized the material, I found that the complainant himself made an absolutely false statement in FIR. He said that I am having a oral and documentary evidence which prima facie, which extensively prove that these messages are forged. I relied on these two words, oral and documentary evidence. Now, so far as oral evidence is concerned, my lord, there are word against the word. I am saying that these two messages I have sent, which was read by one O.P. Mathur. The second message was read by Raigar, Gyanchand Raigar. Now the special investigation team has recorded. I have deposed before I have provided before the Nanavati and Mehta Commission. Now the special investigation team has recorded the statement of this two person, OP Mathur and Gnanchand Raigar. Now this two persons merely stated that the signature, because there is a provision is this wise of the fax message, that if I am sending and someone is reading, then there must be some initials of reader. Endorsement is there. So when I have produced, there was an endorsement of one Mr. Mathur and Mr. Gnanchand Raigar. Ultimately they denied that this is not my signature. So this is the oral evidence against me. I'm sorry, this is the oral evidence against me, that words against the words. I am saying that this is their signature. These two gentlemen are saying. I put a question to myself that in such a kind of situation, it is the duty of investigation agency to find out the truth. Who are saying truth? Who is saying truth? Either Mr. Bhatt or this two person. For that, the procedure would be prescribed, Lord, that they have to obtain the sample of signature of Mr. Mathur and Mr. Gnanchand Raigar, send it to the FSL, get it be verified whether these are the genuine signature or not. Also taken my signature in the reader form, that whether I made an endorsement by myself in the name of third person, send it to the whether it is a signature of Mr. Bhatt himself in the name of Mathur and this Raigar. So this is the duty of investigation agency. Then they can say that we have a documentary evidence. FSL will clear everything. Once it is sent to the FSL, FSL will say that no, this is the signature of Mr. Mathur or this is not the signature of Mr. Mathur. Kahin to FSL ma avat. Surprisingly, this activity has never been done. So the word which is used at the cost of repetition, my lord, I will read that word. Yes. Second line of page number 0009 of FIR, the word which is used after description of these two messages dated Satyaj B. Bejarbar and another have sent the same under his signature. The oral and documentary evidence available on record. So oral evidence is there. Someone has said that no, this is not my signature. But there is no, my submission to this honorable court is there is no documentary evidence on record which shows that, my lord, the signature was forged. So, my lord, in this way, this story of prosecution collapsed, that they are having evidence which shows, because this activity has never been performed to send it to the FSL. Now, if my lord may kindly see, along with this, the prosecution has relied on a statement of one Amin Swaleh Kasiri. Now, this gentleman was Amin Sir, no exact page number pan api do ena statement. This statement, my lord, will find on page number 4415. Just for a ready reckoner, I may supply one form. 4415. It's a bulky charge sheet, that is why, my lord, I have not. Amin Swaleh Kasiri. Amin Swaleh Kasiri. Tongue twist hai un naam se. So, my lord, he is the one of the person, my lord, who was in a duty to see the fax messages. That is his duty. Now, if this message has never been sent, then there was no occasion for him to see this message. Now, this person said that, yes, I have seen this message. I may read only, my lord, his statement's relevant portion. Sir, I may supply, for the ready reference, I may supply this copy. It is there. The compilation which I have supplied, sir, case status joda apne a statement है, statement of Amin Swaleh Kasiri. Page number 4415 of charge sheet papers.
So, as per your say, these messages were never sent.
OP Mathur, the reader of those two messages contains the name of reader, signature and initial that we have read. Now, those two persons are become, as per my say, they turned hostile. That no, we have not seen and we have not signed. but that is not sent to the FL. Now, this is the person who was working there. He said that, yes, I have seen those messages. This is the contradictory versions, and it is in support of the plea of petitioner before the SIT, before the Nanavati and Mehta Commission that I have sent them. So, relevant portion I may read. Paragraph number 3. I may read from the paragraph number 2. As per my recollection, on 27/2002, when the Godhra train incident, sir, this is the regarding his. Subsequently, paragraph number 3. Subsequently, another fax message number so and so 173, which has been also been written by the Constable Jadeja, so and so was sent by me. I have seen this message. That is also not relevant. The last paragraph. I remain present in state IB control room throughout the day, and a lot of messages were sent through the IB control room. Today, I have been shown a photocopy of the office copy of fax message number D22 communal error 100/2002. That is saying that I have sent this message. 27/2002, purportedly sent by Shri Sanjeev Bhatt, then the Deputy Commissioner to CB Ahmedabad, with the information to PS to CM Gandhinagar, PS to famous Home Gandhinagar, Home Secretary Gandhinagar, and Police Gandhinagar on behalf of additional DGP Intelligence. On going through the said fax message, I state that I have been seen this message earlier. But he is not aware whether I have forwarded to other. But he is admitting that yes, I have seen this message earlier. So here in my humble submission, the story of prosecution collapsed. That this message was first time produced before the Nanavati and Mehta Commission, and it was not sent. He is admitting that I have seen this message earlier. So, my lord, this statement reveals that it is not the forged one. Now, my lord, during the investigation, the statement of this Gyanchand Raigar was recorded. He is the person who denied that I have not signed. I don't know how my sign was there on a reading of message. Here, my lord, the crux of the matter is that whether my case is that, my lord, that once I came to know that something is going to be happen in Gulbarga society, when I was not knowing, they are saying that this is the hedged conspiracy. But if my lord may kindly please see the name, the fax message which I have sent, where even I have not mentioned name clearly. I have said Gulmarg. Actually, the name is Gulbarga. But Mr. Bhatt was not aware about that. So, my lord, Gyanchand Raigar, who denied his signature, that I don't know how the signature come over there, his statement was recorded. The crux is that, my lord, whether my case is that once I came to know that something is happened over there, being an officer, I have informed the concerned authority. I have sent the fax messages and I have informed them. They are saying, no, there was no message and this all are concocted. Now, this same person has admitted that Mr. Bhatt personally came in my chamber and introduced me with the fact that something is happening in a Gulbarga society. So, if I was not aware and I have never sent a message to the authority just to show the alarming situation in a Gulbarga society, I could not go there to Mr. Raigar. And Mr. Raigar is admitting that yes, he came, though he turned hostile and he said against me, but he is admitting this fact that Mr. Bhatt came in my chamber and discussed about the Gulbarga. I may read only the relevant portion of his statement, recorded dated 17/2002. My lord will find on page number, it starts from page number 44. I'm sorry. It starts from, my lord, page number 4420. It is there in compilation. Sir, pagination thoda alag se because I have prepared as per this. 4420. My lord will find the relevant portion, various questionnaires put to this gentleman, and my lord will find relevant portion on 4423. The last question. Oh, that's it. We are reading chart sheet number. Sir, original chart sheet ma page number 4420 થી એનો statement start થાય છે. Sir, relevant portion is on page. Sir, page number છે ને ઉપર આપ stamp થી I think.
It is there in your this compilation.
Yes, it is there. Lao sir. હું આપને શું કહું.
44.
4420 સાહેબ ટોપ ઉપર રાઈટ સાઈડ માં પેજ નંબર આપે છે. પાછા 401 ને એવા પણ આપ્યા છે. But this is the charge sheet page number.
4420. Okay, yes.
Statement dated 26/3/2011. Statement of Shri Gyanchand Raigal. I am with my lord.
Yes.
Yes. Now, my lord, the relevant portion is a lengthy statement. My lord will find the relevant portion on page number 4423. The last question. I may read. Question. Did Shri Sanjeev Bhatt, the then DC intelligence, convey to you about the mob attack on Gulbarg Society in Meghani Nagar in forenoon of 28 February 2002, where late Ehsan Jafri, ex-MP, was residing? Answer. On 28/2/2002, sometimes in afternoon, Shri Sanjeev Bhatt, the then DC intelligent came to my chamber and conveyed a message based on a local IB unit Ahmedabad city report about the collection of a mob outside the Gulbarg Society where late Ehsan Jafri, ex-MP, was residing, and also about the inadequate presence of police on the spot. This message was passed on to the Ahmedabad City Police Control Room. I, along with Sri Sanjeev, but also met DGP immediately thereafter and informed him about the developing situation at the Gulbarg Society in Meghani Nagar area. The DGP was so requested to impress upon the CP Ahmedabad City to declare curfew in the area. The DGP immediately rang up Sri PC Pandey, the then CP Ahmedabad City, to know the factual position. The Commissioner of Police Ahmedabad City informed about the DGP over the phone that curfew had already been imposed. So if I'm just trying to draw the attention of this honorable court and making my submissions this way, that if suppose I am not doing this about the Gulbarg, I have not sent the fax message, then there was no reason for me to intimate even personally to him. My case is that I have sent him a fax also. He said, no, that is not my signature. Fair enough. But I am the person where he himself is admitting he came personally and informed me about the Gulbarg Society. So this is one of the reason, one more reason, my lord, to believe that the fax message was sent was not fabricated, but it was a genuine one. Now, if my lord may kindly see the third allegation which is raised against me, that I claim to be present at the house, at the CM house on 27 Bay, 2000 Bay. And I said lie. I was not present. This is the allegation. Now, for that, my lord, they have recorded various number of statements, which shows that Mr. Bhatt was not there. Again, this is the oral evidence. There are statements, my lord, references there that Mr. Bhatt was not there. In my humble submission, this statement which denied my presence, those all statements prima facie unbelievable. They are contradictory from each other. The statement is this was, my lord, one of the witness who claimed to be a present at CM house, he claimed that I was present. At that time, then CM was present, and along with us, there were 3 persons. Other says there were 4, other says there were 5, other says there were 6. Some of the witnesses are saying the meeting was held for 20 minutes. Some of are saying that it was for 40 minutes. So there is no, my respectful submission to this honorable court is that there is no consistency in the statement of witness. And on the basis of inconsistent statement, on the basis of contradictory statement, the investigation officer reached to the conclusion that I was not present. Fine enough, I was not present. But on the basis of that you have asked the conspiracy to harass implicate the accused person. Whether I was present or not present, fairly, sir, I submit that it is a matter of trial. Even I cannot claim myself that I was present. I don't have any evidence to show that at present. But simultaneously, when they are saying that you were not present and they are making this statement on the basis of the statements which is given by the witnesses, they are contradictory to each other and they are irrelevant with each other. That is why even they cannot say that I was. My lord, I will read first statement of one of the witnesses, Mr. P.C. Pandey. Yes. On
These
page,
all witnesses tell that you were not present.
yes, their case is that I was not present. But I have claimed I was present.
You have claimed that you
No, no,
you were
they-
present.
Yes, they are saying that I have claimed wrongly.
Yes.
So in light of my lord, this submission, if my lord may kindly turn to the page number 4335, the compilation which I have supplied. The statement of Sri P.C. Pandey. The question number 2. On same page, question number 2. The questions have not been numbered, but my lord, બીજો જ પ્રશ્ન છે. Did the chief minister call? Am I with my lord?
Yes. Yes.
For the review of communal situation in the state, kindly specify the name of the individuals who had attended the meeting and give the details regarding the place, timing of the said meeting, what were the deliberations that taken place. Answer to this question had been furnished by me on previous occasions at more than one place, including the Nanavati Shah Commission and the SIT inquiry into the Jakia Japri's complaint, and also in the present case is that CR number 6702. However, since the question has been asked against, I would like to clarify that this meeting took place on 27 May 2002 at the residence of the Chief Minister, Gujarat State at Gandhinagar, somewhere around 22:30, 23:00 hours. The persons who were present included the acting Chief Secretary, Srimati Swarna Kantavarma, Shri Ishok Narayan, Shri K. Chakravarti, the then DGP, and I. I do not recollect if Shri K. Nityanandam, then the then Secretary Home, was present or not. To the best of my knowledge, there was no other persons present in the meeting. Lastly, barely 15 to 20 minutes, the decisions centered around maintenance of law and order in view of the Bandh called for the next day and likely replications available forces was generally discussed. So as per my lord, the version of Mr. Pandey, he along with the CM, there were 3 persons. So total 5 persons were there in this meeting. It was held 22:30 to 23:00 hours. Around 15 to 20 minutes.
Okay, I have taken note of that. That there was no consistency and contradiction in the statement of witnesses so far as presence of.
Yes, not only present. None of the witness, I fairly submit, none of the witnesses said that I was present there.
Yes.
So I'm not pointing out that aspect.
But so far as the number of persons present
Number of
and
persons,
the time of meeting,
even
that had,
surprisingly, one person is saying that he was not present, the another person. And his statement is recorded that yes, I was also present. The another person is saying, I am not aware. We are the only 4 or 5 or 6 persons were there. Surprisingly, my lord, the third person is saying that no, I was also there. This is the major contradiction. If I'll read, my lord, only relevant portion of Mr. Chakravarti's statement, next page on 4341, the relevant portion on page number 4342. Question number 2 of that page, 4342. Did you attend? Am I with my lord?
yes, yes.
Did you attend the meeting called by Chief Minister on 27 May 2002 late in the evening in his residence? If so, who else were present in the said meeting? On 27/2002, late in evening, while I was in a Doordarshan studio at Ahmedabad city, I received a message from the state control room that the CM had called for a meeting at his residence of Gandhinagar around 22:30 hours. Reached CM's residence alone a little earlier and waited there. As the CM had not arrived by that time, subsequently Srimati Swama Kanta Verma then Acting Chief Secretary Shri Ashok Narayan and the ACS Home Shri PC Pandey, then CP Ahmedabad City and Shri K. Nityanand, then Secretary, arrived in the meeting. That meeting was held for 20 to 30 minutes, around 23 hours, could be little earlier. Now, here, my lord, addition of one more person. Now, in the next statement of Nityanand, where the PC Pandey has said that I was not aware whether he was there or not, but not there. In his statement, entire picture will change. On my lord will find on page number 4350, Shri K. Nityanandam. Last question on this page, my lord. 4350, last question. Am I with my lord?
Yes.
What was the duration of the meeting? Individuals who had attended and the deliberations took place in the said meeting. The meeting was held around 11 o'clock on 27 Bay, 2002 and went for about 40 to 45 minutes. Duration have been changed. As far as I recollect, apart from me, Srimati Swarna Karma, then the Acting Chief Secretary Chakravarti, then the DGP Shri Ashok Narayan, then the ACS Home Shri PC Pandey, then the CP Ahmedabad City were present in a aforesaid meeting. One of the CM officers was also present, but I cannot recollect exactly whether the Shri PK Mishra and Anil Mukim. So he is doubting the presence of Mr. PK Mishra and Anil Mukim. So as per his version, he along with the CM, 5 more persons were there. 3, 4, 5. Now, if my lord may kindly turn to the next statement of Mr. Mishra, PK Mishra, where the earlier statement Nityanand was not aware whether he was there or not there. On relevant portion, my lord will find on page number 4354, second question of that page. Apart from, kindly name the individuals who had attended the meetings and the deliberations which took place in the said meeting, apart from Srimati Kanta Verma, then Acting Chief Secretary Shri Ashok Narayan, then the ACS Home Shri K. Nityanand, Secretary Home Shri K. Chakravarti, then DGP Shri PC Pandey, then the CP Ahmedabad City Shri Anil Mukim, then the additional PS to CM had attended the aforesaid meetings, Shri Prakash Shah, then the then Joint Secretary in the Home Department looking after the law and order could have been in this meeting. So, my lord, here he has said that total 8 persons were there. The last two, my lord, I've already taken up much time, but my lord, this is the very bulky investigation. That is why I'm extremely sorry for that. The last two, the first one is page number 4363, the statement of Mr. Anil Mukim, who have claimed to be not present in meeting by other witnesses. Now his statement was recorded. He has said, last page, last question on the same page 4363. Did you attend the meeting held at Chief Minister's residential late in evening 27/2/2010? Please name of the officers, politicians who had attended the said meeting. On the return of the Godra, I accompanied the CM to his residence and reached around 22:00. At CM's residence, Srimati Kanta Verma, the then Acting Chief Secretary PK Mishra, then the Principal Secretary of CM, Shri PC Pandey, then the CP Ahmedabad, Shri K. Srinivasan, the Collector Ahmedabad City, Shri K. Chakravarti, then DGP Ashok Narayan, the ACS Home, Shri K. Nityanand, then Secretary Home were already present. As far as I recollect, none of the ministers or politicians were present at CM's residence at that point of time. Further, the Collector of Ahmedabad City, Shri K. Srinivas, had left the CM's residence before the meeting had started as it done. So, my lord, now the version is changed in the statement of Anil Mukim and total 8 persons were present. Difference are. And the last statement of Ashok Narayan, the relevant portion, it starts from my lord page number 4373. My lord will find the relevant portion on page number 4374. He has replied that he doesn't remember whether the PC Pandey and Nityanandam were there or not there. So his presence of these 2 persons, my lord, they are claimed to be there, is denied by this person. Last 2 line, my lord, on the page number 4374, 4 line, on 27 Bay 2002, Chief Minister Shri So-and-so visited Godra. Time afternoon, returned in the late, in the night, sometimes around so-and-so. On his return from the Godra, the Chief Minister had called for a law and order review meeting in his residence. I attend this meeting. As far as the recollection of the Swarna Varna, the own DGP attend the meeting. along with the staff of the Chief Minister. I do not recollect whether Shri P.C. Pandey, then CP Ahmedabad City, and Shri K.C. Nityanand, the then Secretary, so and so, so and so. On next page, my lord, did not attend the sit, but he has denied, not recollect for those accused, but denied my presence. I am also saying that nobody has seen. So, my lord, these are the 6 versions and 6 statements recorded by special investigation team, where all are the contradictory with each other. And that is why, my lord, their own presence in that meeting is questionable. Now, my lord, my respectful submission to this honorable court is that here the dispute is that whether I was present or not present. This dispute can be resolved, or it can be reached to the conclusion by verifying minutes of meeting. Generally, this is the provision of holding any meetings at the CM house or any other place. They have to mention minutes of meeting, that who are invited in this meeting, what is the agenda of this meeting, what they have worked for this meeting, what kind of orders are passed in this meeting, what kind of steps will be taken in this meeting. So this minutes of meeting is very essential. Just to clarify whether Mr. Bhatt was there or not there. Was there or not there, it can be clear. Surprisingly, my lord, where this question raised that where is the minutes of meeting? Where, my lord? 3958, my lord, the compilation page number. Whereby the 3958. During the inquiry, the government of Gujarat in writing stated that, my lord, that this meeting which is held
Is in the compilation or?
yes, in that same compilation.
Yes.
3958. No minutes are drawn for such a review meeting. Otherwise, this would be clear. I may read. No minutes of the meeting held by the CM and senior bureaucrats were maintained, and instructions were mostly conveyed through phone, which served the twin object of field officers carrying out the conspiracy of program against the minorities and the avoidance of the subsequent monitoring of the actions by the jurisdictional officers. During the course of inquiries by SIT, government of Gujarat has given in writing that it is a general practice that when the law and order position is not normal, the review meeting are held by the chief minister or ministers or the higher officials without any written agenda. It is as further be intimated that in this meeting situation of law and review, necessary instructions are passed and actions are taken as per the need. The government has also informed that no minutes are drawn for such review meetings in the view of the position intimated by the government of Gujarat. The first part of the allegations is established, however, the later part of the allegation that this practice served a main objective in the matters of interference and interpretations, and therefore cannot be commented upon. So admittedly, the state of Gujarat said that the minutes of meeting has not been maintained. In my humble submission, this assumption always in favor of accused. Because they have not maintained record, that is their. Okay. Now, if my lord,
How long are you going to take?
I am helpless because it's a very lengthy, the bunch of allegations. I am
Then
helpless.
also, it is a bail application.
Yes,
To
I
confine
understand.
your argument.
I am just only trying to draw the attention.
You
because
can point out the main points.
I am
Still-
only point out that the allegation which is raised against me, and those allegations are prima facie. I will limited myself to that 4 corners only. I will not take it.
So
Next,
now
right?
when both of you want.
I may request for 16. Sir, it is my bail application. I am behind the bar, sir. I am the only person who faced the urgency. 16. So that my senior friend Mr. Amin is also free on Saturday.
No objection for any day.
Please.
No, but it should not be a long date.
Sir, I will mention in my application that I am requesting for this.
But then also I would be telling you, since it is a bail application, it should not be prolonged for any reasons.
I understand. But it is my humble request if it is kept on 16. So that my lord, Saturday, I will conclude my arguments as well as the prosecution.
But then also not such a long date. I can accommodate you. You can ask me for some shorter date. Even if you are asking, then also I am not going to grant that.
I'll leave it to my lord.
It would not happen that
May I request for 11th in that case?
give an application
Yes.
with a shorter date, mention that date, and I will give.
11th आपने कर दिया। ये तो गुरु शुक्र शनि हुआ था। એટલે મારી નહીં, I am not a
મને કાંઈ નહીં, મને આ કોર્ટ ની ખબર છે.
સાહેબ 11 કહું છું એના બે reasons છે. I think my learned friend,
But see, on in the first sessions, if I continue with the first session for the bail, then entire all the peoples would be waiting for the
in second session, sir,
second session or
that
11,
always my
12.
notes
12.
12. please.
Either you or Mr. Amin or both of you are in the same matter.
Yes, he's right.
Because even after your arguments, they would be taking this.
Sir, the reason I'm saying it may be kept on 12, sir. I will conclude,
I
please.
am ready for tomorrow in second half, day
My
after
lord is
tomorrow.
always ready, but sir,
They have-
my limitations are.
Because once it is started, now I
No issue.